Those who are aspiring to write civil service exam in the year 2026-2027, 𝐃𝐨𝐰𝐧𝐥𝐨𝐚𝐝 Academy starting a new batch on April 23rd on Wednesday. The new name of the batch is Vishwavasu, as this is a Telugu New Year this year. Vishwavasu batch we are launching on April 23rd with our auspicious name. Those who are interested to take coaching online or offline in English medium, they can approach 𝐃𝐨𝐰𝐧𝐥𝐨𝐚𝐝 Academy. They can directly come to the Hyderabad and take coaching, or they can access this coaching online also. This coaching, the time frame of this coaching is 11 months, and we cover all the subjects with respect to prelims and mains. Those who are really interested to take coaching for civil services, they can access 𝐃𝐨𝐰𝐧𝐥𝐨𝐚𝐝 Academy through these phone numbers. They can call, they can ask their queries. The phone numbers are displayed on the in front of the video and also in the comments box of the video. Thank you. Phone numbers and further details can be found in the description box below the video. Interested candidates who want to join this course can fill the Google form which is given in the description box below the video.
There is an ongoing controversy with respect to the amendments to Right to Information Act. In fact, 30 Right to Information activists and civil society groups have stated that the RTI is being destroyed. In fact, the Indian National Congress and the opposition parties in the Indian Parliament are also asking the government to pause, review and repeal. In fact, why this controversy with respect to Right to Information Act? What kind of provisions have been amended? Let's try to understand. We all know well that the Right to Information Act has been passed in the year 2005, and over the past 20 years, every year nearly 60 lakh cases are being filed in the name of right to information. In fact, most of the cases are being filed by the poorer sections of the society, and along with the poorer sections of the society, Right to Information Act has become a weapon in the hands of many information activists and journalists in order to bring out corruption, in order to in fact enforce rights of people, and along with that to know generally what the government is doing. Right to Information has become a very efficient tool. In fact, in the year 2019, there has been an amendment passed to Right to Information Act. Under the earlier act, the information commissioners at the central and state level are in fact given security of tenure and a treatment which is similar to the Chief Election Commissioner. But in the 2019 amendment, what has been done by the central government is, it said that the security of tenure for the information commissioners would be removed and their treatment on parity with the Chief Election Commissioner, it would be taken away. Try to understand this. The information commissioners are the people who are going to adjudicate on the issue of what information can be given and what cannot be given. And most of the RTIs are filed against the government, and if they don't have any security of tenure, the chances of the government exerting its influence over the information commissioners is very high. Because of which reason, many people claim that this will create a conflict of interest and the information commissioners cannot act in an independent manner if they don't have security of tenure. And at that point of time, people said that RTI is being diluted. But today, in the year 2025, the charge is RTI is being destroyed. Why this extreme charge has been set? Primarily because of the DPDP Act. The DPDP Act is nothing but the Digital Personal Data Protection Act, which has been passed in the year 2023. But now the Parliament is framing the rules for implementation of DPDP Act. And in the DPDP Act, there is a provision which is called as Section 44(3). And according to the provision, they are amending a particular provision in the Right to Information Act, that is Article 8(1)(j). Article 8(1)(j) is the act or is the provision which is being amended under Section 44(3) of DPDP Act. And what 8(1)(j) originally contained, let's try to understand. In fact, 8(1)(j) has a provision that any personal information which is not directly related to any public interest or public activity need not be revealed under Right to Information Act. Which means that if any personal information is present which is not directly related to public information and public interest and public activity, it need not be revealed. And any information which unduly, in fact, interferes in the privacy of an individual, it also need not be revealed to the public. And it also contains a provision that any information which can be disclosed to a parliamentarian or a state legislator should also be disclosed to the public, which keeps the people or the citizens of India on par with the parliamentarians and legislators, which empowers the citizens. In fact, we need to understand that these provisions were very, very important, and they try to strike a balance between the privacy of the individual, because personal information is associated with privacy, and on the other side, it tries to strike the balance between the right to information of the citizens. Now, the main problem here is, or there was also one more provision, that is the public information officers will decide whether the information is compromising the privacy or is it enhancing any transparency. In fact, this is called as public interest test, and they conduct the public interest test, that is public information officers, and on the basis of that, whether to disclose an information or not is going to be decided. So these are the important things that we need to remember with respect to 81J of RTI Act. Now, the DPDP section 44(3), what it does is, it has brought in a provision by amending 81J, and it stated that all personal information would be out of public scope. It means that no conditions are attached to it. It just clearly stated that no public information can be disclosed to the public. No personal information can be disclosed to the public is the provision which has been included in 81J now, by removing the earlier safeguards which were present. And what is personal information according to the new amendment? Personal information is nothing but any information that identifies an individual is stated as personal information. And this means that majority of the information which the government possesses can be denied to the activists or to the people who seek information, saying that it is of public or it is of personal nature. In fact, out of the RTIs which are filed earlier, there were two prominent cases. One is the case with respect to non-performing assets. The government initially denied the information to the information activists, saying that the information about the non-performing assets is the private information of some individuals and it need not be disclosed to the public. But the Supreme Court of India, in a very prominent case by the name of Jayanti Lal Mishra case, has stated that the non-performing assets are the loans given by the banks which hold the public money. Because of which reason, it comes under the Right to Information Act, and it will not be limited under the name of personal information, and the information should be disclosed to the public is the judgment given by the Supreme Court. Then thereafter, even in the public distribution case, distribution system also, the RTI activists have got the information from the government about the beneficiaries, what kind of beneficiaries are present, their names, along with their photographs. All the information is given to the Right to Information activists, and through this, the Right to Information activists, they got nearly data of 81 crore Indian citizens who are getting the PDS benefits. Through that, they were able to weed out any false beneficiaries. They were able to identify any corruption that is involved, because of which reason the National Food Security Act is properly implemented in India. Now the thing is, they have completely changed it. So now no personal data would be accessible in the name of privacy, and the government is stating that under the Puthuswamy judgment, protecting the personal information is the responsibility of the government, because of which reason only it is permitting this amendment. But the opposition is saying that in the name of personal information, the transparency which should be given to the public is being compromised. So where to draw the line between privacy and transparency for the public should be determined, and this amendment is definitely going to have an adverse impact on right to information, because of which reason the court should take cognizance of the same, and they should adjudicate where to draw the line between the privacy and transparency concerns, because both of them are part of the fundamental rights of Indian Constitution. So we have to wait and see what the courts are going to say about the same. Thank you.